We have a shorter panel, but it's going to be very interesting compared to the previous one. We have two participant ladies that are online joining us, and they have amazing presentations. And we speak now about international arbitration. So we focus now on the international aspects, and this information shall be very relevant for Moldova, because there is a huge interest, and for me personally, it's surprising to see how many young people from Moldova are interested to go into the arbitration field. Because me, when I was a young person, I had no idea what I wanted to do. I knew that I want to be involved more in prevention, building things like projects. Those who made your practice in our office, you know what is our approach. We are usually approaching creatively. We are also involved in lobbying the legislation. In terms of, so we were kind of a center of legislatory creation, if we can call it that way. So I remember those times, and we didn't have money at all at that time to make any reforms. But now, thanks to our partners, we have this support. And thank you very much for our partners who involve with their knowledge, with their skills, and hopefully we can develop our own tools and get inspired from our friends, from our partners. And definitely, by the end of the day, our purpose is to increase the chances for those that are in insolvability, to give them a second chance to develop our country, to give new opportunities to people, to make people trust the system. So, you know, you young people, and I'm so glad to see so many students in our room today here, you also have the possibility to catch a very nice time in, because, you know, the hot 90s, do you remember? I'm not sure you remember, but, and we faced different processes, same phenomena that happened in Romania, Bulgaria, in Balkans, and by the end of the day, we have so many lessons learned already. And our question now is to understand what path we want to follow. Do we want to follow the democratic path, or because you remember how it was? And again, those of my generation, they know very well what changes, what challenges we faced. And you know that lately we made a lot of changes and a lot of progress. The process of reform is not an easy one. And when you start involving in that, it is very important to have young generation on board, because they are the ones that understand the best the importance of the change. And of course, in our country, we had this history of oligarchs who stole from their own people, and we faced a lot of challenges in that sense. And definitely now is the right time to try to create a better future for us after all the revolutions we passed through. So this, you know, I wrote an interview, I gave an interview recently, and the name of the interview was "Who are the parasites of the society?" So these were the people who stole from their own nation when they got into the power. Okay, let's not go into history, I can talk for hours, but we have our speakers. And I offer the word now to Natalia. She is going to be the first speaker. She is actually the muse of digitalization, and she's going to speak about her experience in arbitration, in digital arbitration. Serghei is going to talk in general about the experience, but from the very practical point of view. That is why we chose these subjects. Mr. Serghei Covali. is very active in arbitration, and she has a lot of experience to share with you. And Natalia is going to speak about this peculiar aspect, digital arbitration. And she's going to speak about her experience in Romania, and maybe we can comment afterwards. Good morning. I am so glad to see so many professionals in this room. Thank you very much to the organizers for such a needed event and such an interesting event. I'm going to speak, but very shortly on the subject, but targeting the most important ideas. About the commercial arbitration and digitalization era. All the socioeconomical events are have also the digital component, and we thought that digital arbitration is very important in this context. Let's call it electronical arbitration. Why we prefer to use electronic and not digital? Because it's more specific, and this actually became a thing in the pandemic, and it's about some procedures that can be developed in electronic version. I will show you a few slides, and I'm going to speak first of all about the electronic arbitration benefits. So this can offer assistance, verification of formalities, and it was application which are adaptable to the user, and also it presents an archive of the previous actions, which is very helpful. So I want to speak about the experience of the court, arbitration trade court, commercial court, in what happened in Romania in 2022. 90% of the arbitrations meeting in electronic version had also the component of video conference. And this means that the Romanian country, the country of Romania, managed to conduct those activities without stopping it, even in the most restrictive times of the COVID pandemic. So the arbitration requests could be made electronic, in an electronic version. Audio, video calls were approved as tools to organize those meetings. So it was different, and also we used electronic messages like mailing. And actually this made the flow of the litigations very easy to manage, because, you know, in the arbitration field, everything went perfectly because we switched to the digital world. And in Romania, it gave the possibility to make the reclamation online, and some requests were made through email, and the need for the arbitrator to be physically present was not anymore mandatory. So people used to work from home, and this subject was discussed. In Romania, it was about a governmental decision also, because it was a temporary measure. We don't have yet a regulation of procedures in that sense, but what is great is that we already have in Europe the platform Fast Arbiter France, which actually gave the opportunity for everyone to use it for solving commercial litigations. And this offers the possibility for the future to have a digital court. And what is surprising is that the first arbitration platform is in Casablanca, Morocco, that was created in 2021. Digitalized and operation. It's just a greatest example of how this can work. we have a list of advantages, confidentiality, the reduced costs, accessibility, all you need is good internet, reduction of the time of the processing, you do not manipulate manually the files, which brings additional transparency. So this is like the classic arbitration, but for example, for France and Morocco, they have this regulation saying that the arbitrator has to sign the contract, and in the contract there is a clause saying that the person knows basic usage of the apps that allow them to make this online, this process online. Then we have the guarantee of confidentiality, although there are also risks. At the initial phase, we have some costs for the management of the platform. Also, we have resistance from the people, but also we have the expectations of the citizens and the implementation of e-justice and digital proofs is increasing. Digital proofs are increasing. What is important is for us as professionals to understand that in the future the arbitration courts will use more specialized tools, specific tools, and we shall evaluate the risks of digitalization and usage of artificial intelligence for the strategy of development of justice. In Europe, it was decided that AI is going to be implemented at the not only on a few segments. But I will not go into details because there are technicalities. And now we have to adapt the flows of work and adapt the competencies for us as professionals working in this field. And the last thing I wanted to tell you is that from my point, every innovation is welcome, but it depends on the people, how they use it. We have some regulations that regulate that field. About electronic communication, the involvement of the court, also the video conference is something that is used largely already for a long period of time. And if you work on a new legislation, I would encourage you also to include this as a tool. It's not a mandatory tool so far, but it should be mentioned as an opportunity to be able for the parties to use it as a tool, because, you know, we professionals, we want to be in front of the arbitration because it's a luxury of our profession, but nevertheless, we have to have some other options, some other tools in order to be in line with the socio-economical trends. Thank you very much. Yes, indeed, it's a luxury for us to be in front of people, but also if analyzing from the perspective of the costs, you can stay home with your family and, you know, do the same thing. And, you know, now there is also the challenge of the cancelled flights, and you avoid those challenges. And sometimes, yes, I agree, it's a huge pleasure to be in Hague as Institute of Justice. It's a masterpiece, but there are challenges also related to that. I think any lawyer should go at least once in his life in the Institute of Justice in Hague. And it would be a pity just to transfer everything to online, but I agree, yes, we should have this tool as an option. And also in the United States, you know, when you go to the main court of justice, when you see that building, it gives you shivers, it gives you a certain state, you know, responsibility. Nevertheless, we go to online, and it would be a pity not to use this opportunity, but we always have to take into consideration the potential risks. You know, we spoke about this balance that should be achieved. And let's see what are the challenges, what are the opportunities, and what are the risks. And if the risks are manageable, I think then we take this on board. And this is very important, definitely. you know, at the state courts, the arbitration cases are not at the first phase public, and this is why we have some obligations, some responsibilities also of confidentiality. And from my perspective, the risk in the online environment is that there are very professional hackers. Nevertheless, you know, Paris, Vienna, London, and this is already about Serghei. Serghei is an international practitioner. He represented Republic of Moldova a few times. He actually won one of the big tenders. Yes, Cătălin, you wanted to say something? I have a question for Natalia and two comments before going to the next speaker. A question that comes from a rumor that I heard with some lawyers from Bucharest. So it was a rumor that some arbitration actions were performed in online, and I think that the law at that point was not yet adjusted to that. So I'm not sure you know something about that situation. Thank you for the question, Cătălin. Yes, indeed, you are right. We took some measures. It was not only for the legality of the decision because of the online tool that was used, but it was also the request of the parties, and it was compared. It was actually explained by the fact that we were not able to move because we were in very strong restrictions in the pandemic. I'm not sure what was the final decision, but I know for sure that these cases existed. Because it was a big discussion. Should the arbitrator be physically present, or he can do it remotely? So yes, indeed, this was a big discussion. And we regulated the field. We actually talked about regulating the field, but the court actually took again the procedures on board after the restrictions were eliminated. Nevertheless, they came to the conclusion that some of the activities, if it's accepted by the court, they can be switched on to the online. And of course, the correspondence through mails is one of the main things that is to be accepted as just part of the procedure, which is in online. And two comments also. Thank you very much for your answer. And two comments. I fully support the digitalization. Switching from a physical file to the electronic file, it's amazing. It's one of the best ideas. So we have to be very careful what we choose, depending on every file separately. So I participated in a few video conferences. I didn't feel any need to be physically there as long as there is good connection. In some cases, it was sufficient to make a written request because it was not mandatory to be like an oral discussion, verbal discussion. But we also had cases when we had to audit a witness, and in a video conference, it was very difficult to cross-examine. I think in this case, we have to appreciate the credibility aspect, and we have to evaluate the case by case. We have to have this approach case by case, and to see when exactly you can do things online and in what circumstances you actually have to be there. Because, you know, sometimes when you look at the witness, it's a complex evaluation. You evaluate the body language, the eye contact, the many aspects. I fully agree with you. I would like to add something. A very largely discussed aspect was the auditing of the witness. We discussed in Romania about this a lot. Of course, it is difficult to make a general conclusion about all the cases, and I believe that we have to just have very clear rules of the games. And when you have a clarity of the rules of the games, everything is okay.
I have an idea of best practices that were implemented. For example, the hearing of the witness through video conference took place in a third-party attorney's office, so that there is a confirmation that there's nobody there to pressure the witness. So the parties took this step and they make an agreement to allow a third party to host that witness. And also, let me add more complication. There was an interpreter there because the witness didn't speak the language. So they made sure and they took measures to solve this situation. Yes, you are right. When you look at the situation face to face, you discover many elements. I heard about this initiative to digitalize, and I heard some lawyers saying, no, I don't want to do the cross-examination online because I want to see the witness to make sure that the witness sweats. And I was thinking, why would you care about the sweat of the witness? But, you know, for the lawyers, everything matters. Okay, now there is more secured channels. They use IT tools to do the documentation, and yes, maybe sometimes you don't have the luxury to travel and to plead in court to see face-to-face the judges. So if it doesn't happen, if you don't have the opportunity, digital tools are very welcomed. And actually this can open the door for other professionals. Not everybody has this art of public speaking and to convince face-to-face. Not everybody has a car to drive from Yedinets to Cahul to cover all these kilometers to make sure that you arrive in court. And oftentimes, the sneaky lawyers of the opposite party can say, why not let's make a meeting now and let's not delay anymore. So then you are late and you lost a case, and this can lead to the European Court of Human Rights, and Moldova can lose. So these digital tools can ensure efficiency and can help remove backlogs, which happens a lot. And now the judges don't have if they will have good digital tools, the judges cannot say that, oh, we didn't have the technical means, the lawyers didn't come. And let me share an example from our institution. When we started working online, it was actually much easier. For me, I was in my office, everybody was looking at me, and I was seeing 15 faces on my screen. When in reality, what happens, you sit in court, and you have many people in the room, but somebody they are sitting face to face, not looking at me. But in the screen, I can get to see everybody. The only thing I'm missing, and I don't notice that they're sweating, but I don't care about that. Yes, but I actually noticed some recording, and I saw even the sweat. So the digital tools are actually pretty good. Yes, but sometimes people don't switch on the camera, and you don't know if they're sitting there or maybe the cat is participating. Okay, thank you so much for all of this opinion. If I can continue to what Madam Natalia Balaban said, and I want to lead in to the international arbitration procedures. So let me speak about the complications. The complications came because of online proceedings. It happened during the pandemic. That was the situation that despite our desire to meet each other face-to-face in London or in Stockholm, the restrictions happened. We had to use the tablets, computers, and deal with the reality. And we had some procedures. We had 2 hearings, and every hearing lasted for 5 days, from the morning until the end of working days. 5 days for one case and 5 days for another case, and instead of 6 months or something like this. So obviously, I was analyzing this experience for me, for the client. In one case, the experience was positive, and in another case, the experience was very positive. Me, as an attorney, I felt very good. Okay, I didn't work with unprofessional witnesses. I didn't work with unprofessional people generally. The pleadings were okay. It was, and I think even for the arbitrators was pretty comfortable. The only difficulty was cross examination. We actually felt the need to have additional video cameras to show what is happening behind, in front, but we quickly understood that all the parties involved are very serious and decent people, and they do not want to put their reputation under discussion. So we didn't notice any attempts to cheat or any attempts to mislead us. So the cross-examination took place through video, and according to my impression, it was okay. Okay, I wasn't able to see the sweat, but from my experience, even in the room, I don't notice the sweat. So if I were to go back to choose the style of the meetings, I would choose the online meeting because it takes less time. And from my experience, it's possible to do cross-examination as well. And also, for another arbitration process in Hague, the permanent arbitration court was involved. They gave us some special letters with which we managed to solve the documents and fly to Hague, and we had a meeting during the pandemics. It wasn't the initial time when nobody was allowed to fly. It was further on when some restrictions were removed and flights were allowed with some additional procedures. So we received a special letter and we flew. But I believe that we would have done the same procedures online and it would have been better. But this is just my personal opinion. And we can actually continue to discuss with the digital tools on many topics, many interesting topics. And such a conference like this conference is a sign that we are growing to the next level in terms of arbitration. So I hope that such meetings, such international conference will become a tradition so that we can grow and we can promote this sector. And by the way, I was talking to my students, speaking about the example of Great Britain, the material rights. France sells, in quotes, air quotation, sells the jurisdictions as a place of arbitration because France has a solid experience. You know what it happens if somebody goes and attacks an arbitration decision in France. Americans, on the other hand, they have a case law, a very robust case law. Even though they have different jurisdictions, at federal level, things are very clear. I can give you the example of Sweden and Switzerland, and the question is what Moldova can provide. And I didn't reply to this question. Why? Because we can even raise our level and the client's level when we participate in international arbitration procedures. We can raise ourselves to the level of the British, of the Swedish, of the Swiss, even though locally we are not there yet, but by participating, by being ready and representing clients in international arbitration courts, we can elevate ourselves. I have 4 case studies to present to you. I don't know if I'll have enough time to present all of them, but let's see how much I can share from my own practice. First problem that I would like to mention are the arbitration agreement with multiple levels or layers. Okay, it's easy when it says in the contract that in case of a dispute, the parties will appeal to the arbitration court in this jurisdiction in this allocated time, 30 days after submitting the initiative. Then we discuss with the parties, then another 30 days, etc., etc. And only after that it's not solved, then you can initiate the arbitration procedure. This will be a simple example of arbitration agreement. A more complex example will be construction FIDIC contracts, usually used in road construction in Moldova. These contracts have a higher layer of arbitration. So you can have a dispute with an engineer. You can go to a independent expert, and then if you are not happy, you can go to arbitration. So you can try to remediate friendly, then go to the expert, and then to arbitration. Another example is a contract of petrol use closed between the so-called production ensuring contracts. And here we have different layer of mitigation of arbitration. First, the parties have an opportunity to agree, then they go through mediation, and then the rules of mediation, the deadlines, the time frame, and only after that fails you can launch the arbitration. And there's usually a deadline for every phase, 30 days, 60 days, or more, maybe 3 months. The issue with these different layers is that when the parties go to arbitration procedure without following the time frame or without following the consecutive steps, right? They jump instead of going to mediation first or trying to settle friendly the dispute, they go directly to arbitration. And actually I was asking if breaking the steps is a issue related to the arbitration court, or is it related to accepting the request or the claims? So it's not the decision of the arbitration. So this is not a theoretical problem. If it's an issue of competence or jurisdiction, then there is a ground for refusal of this claim. But if it's a problem only if the claim is the issue, then the arbitration court looks at the date and decides if it's admissible in court or not. But it doesn't question the competence or the jurisdiction. So there are different cases and it depends on the claims. But obviously, we can have a very long discussion between attorney, arbitrator, but it matters the court as well. It can happen that the court can take a decision that there is an issue there with the competence and they can remove the initiative. In the procedures where I participated, usually the parties didn't skip steps, but they were delaying and they broke the deadlines. That was the issue. And I was asking, is the arbitration court losing its role because of the delays? And they said it's only a problem, but it's not an issue. Actually, they didn't comment a lot. They didn't say that this is a problem of jurisdiction. It's just some delays, and there is actually a regional yes, it's a regional understanding that this is not a problem, but we have also the decision of the Supreme Court, which issued some contradictory decisions on this topic, and it's one thing to miss a deadline, and it's another thing to skip 2-3 steps mentioned in arbitration agreement. I saw the situation when the courts unofficially suspend the procedure and allow the parties to go back to previous steps, to go through all the steps mentioned in arbitration agreement. Second is the Supreme Court of Justice in Moldova, which is not a problem, but it has some contradictory decisions. At some point, we were discussing a theoretical subject in a contract, and our contractual law manuals were not covering this topic. It was a minor element, and we, the attorneys, we were trying to present arguments. The law was the national legislation, and obviously every attorney was trying to prove their point. In front of us, we had 3 arbitrators, one from Germany, one from France, and one from UK, with very different background, and everybody was reading the same law in their own language and understanding it through their own experience. And at some point, we brought some precedents from the Supreme Court of Justice that was supporting our claim. And the opposite party found other decisions of the Supreme Court of saying that these decisions are not mandatory in Moldova. Oh, I had the right to argument here. We said that in the highest court of the country, in the Republic of Moldova, it was discussed the same provisions, the same elements that we discuss in this arbitration court. So why not listen as a recommendation, as a strong recommendation, the decision of the highest court of Moldova? You can agree, we can disagree, but why not take it into account? Let's look at the arguments that were presented there. I don't know why we should ignore it just because these decisions are not mandatory. And in the decision of arbitration court, it was accepted, this approach, and they considered the solutions mentioned in the Supreme Justice Court, and they followed our approach. Third problem, British specialized arbitration. So it's not a problem, but it is a problem only for those who don't think that they should consider it because they're not mandatory. Yes, I had another experience. I was in an arbitration court on a Moldovan law. I referred a decision of the Supreme Court of Justice, and the arbitrator said this decision is not mandatory and let's ignore it. And we lost, despite the fact that there are different approaches that take into account such cases. Okay, in our case, the arbitrator was French, and as you know, in France, they take into account the court of cessation and the real relevant precedents. But the British arbitration, because I was involved in a number of cases, it feels like they are on another planet, and they're very uncomfortable for those who are not accustomed to international arbitration rules. We involved the FOSFA Federation, and the GAFTA was involved, and the Maritime Association for Arbitration in London. I had contact with them. So what I noticed that you can have experience in international arbitration, but then when you work with these three entities, very different procedures apply. They don't follow anymore the international arbitration, but they follow the British civil procedure. They follow, they only use a very limited number of arbitrators who are specialized, and oftentimes the litigation is connected, and then there is a recusal procedure, and then there's an impartiality claim, and then the impartiality claim is ignored because what do you expect on feed and seeds? We are the only arbitrators, so you have to listen to us. So it took me months to understand how is their working procedure and to understand what is the British concept, what are the principles, what are the procedures, and because they did not follow the international arbitration processes. They were mostly following internal procedures, so we had to adopt. And the last point is related to the behavior of attorneys. Sometimes the attorneys involved in international arbitration procedure behave as if they are in front of a national court. I had situation when I saw a lawyer coming to hearing, which was scheduled months in advance. We had a calendar. Everybody knows what will be discussed. Everybody knows the time, the hour. And right before the meeting, he said, wait, we don't have the request. We don't have the initiation procedure. And we were shocked. What are you talking about? You can't act like that in such a procedure. And actually, this procedure happened outside Moldova. And by the way, I noticed this behavior not only within the Moldovan attorneys, but I noticed other international attorneys doing the same. Or I noticed some lawyers referring to the legislation of one of the countries of the parties, but not following the international procedure, or mentioning the French code, which had no connection to the case or to the. So we had such situations as well. So you have to be very well prepared, and you have to be ready to face that level and not apply national civil procedure codes. We usually work with rules applicable to one institution. Even if you do it ad hoc, you still agree on the rules first. I would say this is all, and in conclusion, we are not in the Great Britain, we're not in France, we're not in the US. I don't think we will get to their level anytime soon. And actually, it's not our objective to be part of their jurisdictions, but we strive to participate in a high-level, high-qualitative way to represent our clients as best as possible to the level that they deserve. This is my conclusion. Thank you so much. If I may, Serghei, I have a question and a comment. First of all, a question regarding the first issue that you mentioned, the multiple layers in arbitration agreements. I know that in Romania we had many discussions about it, and I was wondering if you found a solution in Moldova, especially related to the limitation time. So, for example, in FIDIC case, there are multiple layers and phases of the procedure that take so much time so that the limitation expires. So what did you agree? So far, in Moldova, there's no solution. And in practice, I also don't know about a solution. We have very few cases that arrive to arbitration, so we don't have a lot of practice. I remember in the past I was working with a Romanian attorney, and they asked me, when do you start to calculate the time frame and when your time frame expires? What is the status of limitation and when do you start to calculate it? And I was surprised because we don't do that. So then I looked into the civil code, what it says about the status of limitation, and I noticed that the status of limitation starts when the right for action starts. So when we go in front of the arbitration court, when we launch the procedure. So if we start calculating from when we send a request to the judge, then this is not correct for the right holder, because this procedure can take so long, months, even more than a year, and then the statute of limitation then is expires. So from my experience, I hear many arguments in front of the court about when to start to calculate. Okay, thank you for sharing your experience. The civil code also uses the term reasonable calculation. So to comment about what you said about the decisions of the Supreme Court of Justice, yes, we have the same situation in Romania, and I think that this gives a additional burden on the judges so that their decisions of Court of Appeal be solid, because you don't have another opportunity to go to the Supreme Court of Justice. So the Court of Appeals has to have extremely good cases, persuasive decisions, to not go to the Supreme Court of Justice. Yes, I agree, but I think that now we open another topic. It was discussed earlier that we are now running a justice reform and removal or combating, fighting corruption. So this is also an effort. And when I read about arbitration, the argumentation in the decision, it's still quite low in quality. So I don't know, I think we need to work on it. So when there is a weak incentive of the court, you receive such a weak decision. Recently, I was in front of the Court of Appeal. It was a decision issued. It doesn't matter if I agreed or not with this final decision. And when I read that the formulation of the decision, I understood that this is a problem, and we should work on helping the justice makers to formulate and to argument their decisions. Yes, to bring more light. Yes, thank you so much. I would love to arrive to the day when I read the decision and the arguments that make sense, because usually the decision has like 20 pages where it says what the party said, then a few pages of from other relevant cases of the European Court of Human Rights, and then when you want to read the arguments based on which the decision was taken, it doesn't make sense. And then the question raised by Serghei, what we can offer to London, Paris, Stockholm arbitration court. Yes, you say that they have more experience, but let's not discourage ourselves. Serghei already examined the first litigation that we had in arbitration. You analyzed even more cases. This is the first thing. What we do we offer high-quality professionals with the knowledge of the local context. It doesn't mean that we ignore other international courts' long experience, but we bring the local perspective. I don't know if there are any arbitrator in Romania who knows the Moldovan context. So we come with local professionals that know the local context, local legislation. They know the acquis communautaire, they know the Romanian context, they know the international rules. By the way, I had a situation when the judge said, "Did you bring me a copy of the British law?" And I said, "Wait, we're not talking about that point." So there are some strange elements that happen with which our specialists are aware, and we hope that when we meet at the next edition of the conference, we will hear less and less of such cases. So what else can we provide beyond the local specialists? We have a list of arbitrators. And we are flexible. The parties can bring their own arbitrators. We are here to accommodate you. And fast procedure, 6 months, and we have to provide a decision. And thus far, the arbitrators followed this rule. They didn't come with a complaint that, oh, we have so much work to do. No, they followed the deadline. And reduced costs. As you know, the arbitration costs are very high, up to the millions. But we want to be competitive from the costs point of view. And now even the state understands this and supports this. There's no ceilings that existed in the past, and the ceilings actually represented a window for the smart, for the sneaky guys. So we hope that these situations will not repeat itself. And because we were talking about time, value, money, let's go to the next speaker. Katerina, are you ready? Do you hear us?
The next speaker comes from Prague, I think, right?
Hi. Can you see me?
Hi, Katerina. Yes, we can hear you and we can see you. Thanks for joining. Okay. Just let me introduce a couple of words. And it's very amazing how your title is Director of Dispute Advisory Center of Excellence. So it seems that Katerina is dealing with all those things which are making the difference in the arbitration proceeding. Because in arbitration, as in probably any other field, the devil is in details, right? And we've just spoken about. I told about my experience of expert witness, and I hope you can augment this with your experience, which seems to be much more sophisticated and elaborated. Because this is very interesting, how to ensure on the one side the independence of the witness, and then on the other side, the quality of the deliverables, let's put them generically. And the second issue, which we've been just discussing, is the issue of time value of money. In particular, how you quantify and how you reason your demands for something, be it damages, be it any other claim. But damages in Moldova is very interesting. You know, courts are yet very reluctant to award the lost profit, for instance. And if you want to refer to this, that would be very interesting for us. Or the damages relating from the reputational damages. And I have a friend who was unlawfully arrested, and then he went to court to claim damages for breach of his personal reputation. And his claim was formed of 16, I recall, issues. And the Supreme Court awarded him 16,000 lei, which is around 800 euro. That's how they quantified his dignity and his reputation. Yeah, please, the floor is yours.
Okay, thank you for the introduction. So as you mentioned, the issue of damages is actually at the center point issue in international commercial and also investment treaty arbitration, because in the end, what the claimant want to receive and what the respondent does not want to give is the money, and the the compensation actually for the damages. So what I'm gonna do today is I'm gonna walk you through several issues which came from the study of for actually several studies PwC did. We have done two types of studies. One of them being more relevant for this panel on commercial arbitration, international commercial arbitration cases. For these cases, the awards are usually not publicly available. Therefore, we did this study together with Queen Mary University of London, and they analyzed for us claims containing 284 separate heads of claim. And based on their analysis, we have developed this damages study, and we have identified issues in damages calculations. And what we did just as PwC was the research into publicly available cases, which are the investment treaty cases. And we have actually done this study already for several times. We have done the latest update in 2022, where we have analyzed altogether 181 publicly available awards in international arbitration. These, as I mentioned already, are mainly investment treaty cases because the international commercial cases are usually not publicly available. So those are mainly from ICSID, UNCITRAL, Stockholm Chamber of Commerce, and other arbitral institutions. So my focus today, as I mentioned, is going to be on the international commercial cases. So on the first slide, you can actually see that these are dominated by industrial and energy sector. And actually, it's very similar also for the investment treaty cases, where the main issues are around construction. These are the types of damages which are usually claimed in the ICC cases. So it is on prevalent cases, it is a claim of direct losses. In other numerous cases, it is a loss of profit. And you can see that these numbers are higher than the total number of cases we actually studied, because usually the claimants are claiming more types of losses. So in terms of parties who participated in the cases which we studied, these were parties from all over the world. As you can see, we have gathered them into clusters. So majority came from the Western Europe, and then the main coverage was MENA region, and also North America and Central and South America. Individually, the most frequent cases came from UK and US. From our study, we have actually found three main issues, broad themes, which are worth discussing and which are worth looking into in more detail. First of them is actually the methodologies which the parties are adopting to assess the losses, and the criticism which is then provided by the tribunals in their awards. Then what is the gap between position of the parties and then what tribunals actually decide in the award. And last but not least, we have also looked at what impact does it have if you use an expert to assess damages, in opposed to when the claimants are assessing the losses themselves, and also to look at the gender disparity, what is the gender gap between experts. And we have also looked at what's the gender gap between tribunals. So if you look at the first issue, which are the methodologies adopted by the parties, I have put into this slide actually because I don't know how familiar you are with the methodologies used to assess the losses. So I have put in a brief summary for the methodologies which are the most commonly used. So the first one is the income approach. And in the income approach, these are actually claims for lost profits and claims for lost value, which is usually being assessed through use of discounted cash flow methodology. These approaches actually estimate the income that would have been generated but for the alleged breach, but for the harmful actions of the respondent. And this methodology is basically forward-looking. So we are looking what the damage is because of the breach in the future. The other forward-looking approach is the market approach. And in this approach, we are basically comparing the businesses, assets, or goods and services to similar comparable businesses, assets, or goods or services, which are called comparables. The next two approaches, asset approach and sunk cost approach, these are actually backward-looking approaches. The asset approach assesses the market or book value of the assets net of liabilities. And sunk cost approach, it is basically the historical cost of investment or wasted expenditure which happened because of the breach. Then there are other minor methodologies how to assess damages, and we haven't really focused on the other ones because basically the first four are claimed in majority, like 99% of the awards. So when we look at how much of the claim is being assessed as damages by the respondent compared to the claimant, it's usually 12%, meaning that when the claimant put forward damages which are like $100 US, then the respondent would say that the correct number is $12. Yeah, so the parties are usually a long way apart, which can actually make the appearance that the experts are sort of hired guns by the parties. But usually the issue behind this is much more complex. The expert in any case should be independent. But what is usually the cause of this is that the experts might be given different instructions, they may be given different factual information, or there might be actually genuine different opinions in claimants and respondents' valuation, like disagreement on the methodology, because usually if you don't believe into the business, you would never assess it using the income approach, but you would rather use the sunk cost approach, which ultimately results in lower result. So going further, what are then the methodologies adopted by the tribunals if put forward by the claimant? So there is a distinction between the international commercial cases and the investment treaty cases. In the international commercial cases, the tribunals usually award the sunk cost, whereas in the investment treaty cases, the income approach is used much more often. The other approaches are not so common. With the market approach, there is a problem that you are usually not able to find such a comparable comparative. And the asset-based approach, it actually does not give you the full amount of the damages which you are claiming. So if the tribunal decides, they usually go either for income approach when they see the business as a going concern, or sunk cost approach, where they do not consider the income approach substantiated because they don't see the evidence of the business actually developing further. So the next very important issue is where the tribunal actually see the main problems in the methodologies and what were their main criticism of the quantum approach by the claimant's experts. So on majority of the cases or the heads of claims, it was lack of evidence. They basically considered the damages assessment unsubstantiated. The second one was the underlying assumptions were based on tribunal decision wrong or unconvincing for them, or basically the assessment was too speculative. The fact that these three issues are the top one is not surprising. What is very interesting is that these three issues were actually identified in almost half of all cases. Yeah, so this is one of the reasons why it's important to actually engage an expert which can help the claimant or the respondent to actually support the claim or to disprove the claim by the claimant. So when the tribunal criticizes that the claim is lacking evidence or is unsubstantiated, on average, they would award 39% of the claim. If they were not sure about the underlying assumptions or they consider them wrong, they would assign 30%, they would award 30% of the claim to the claimant, and the same percentage of the claim was awarded if the claim was considered too speculative. So then we are going to look at what is the gap between actually parties' position and tribunal's position. And we can see that on average, in the cases, the claimant would receive 53% of the claim. So this could actually lead to the view that the tribunals are splitting the baby, so basically deciding for half. Yeah, this 53% is for the ICC cases, so International Commercial Arbitration. In the investment treaty cases, it was actually on average 40%. But this rate has fluctuated over time, and in the most recent 5 years, also for the investment treaty cases, the ratio reached 50%. On the next slide, we can actually see that the tribunal is not splitting the baby, both for the commercial arbitrations and investment treaty cases. So for the commercial arbitrations, you can see that for the majority of the heads of claim, 100% of the claim has been awarded by the tribunal, as opposed to the investment treaty cases, when on a majority of the cases, only 1 to 20% of the claimed amount has been actually awarded. And this is mainly because in the investment treaty cases, the claimants and respondents are more likely to adopt a different valuation method, which has been put forward by the claimant. And there might be then sizable differences between the amounts claimed and then awarded. Because, for example, where a claim based on lost profits meets an award based on sunk costs only. The sunk costs are usually a very minor part of the lost profit claimed. So coming actually to the last topic, which is the impact of using an expert in damages assessment and the gender gap. If we look at the numbers, we can see that it is actually for the cases where the climate expert has been involved, it has been usually awarded much higher compensation as opposed to when also a respondent's expert has been involved. So this is actually an advice for the lawyers and for the respondents to rather involve a respondent expert in order to be able to push the claimed amount a little bit lower, because the respondent's expert can bring in different perspective, look at the reasonableness of the assumptions. So here is the average, which has been actually awarded by the tribunal when the claimant has an expert and respondent does not. Then the claimed, on average, 69% of the claimed amount has been awarded. But when both sides appoint an expert, meaning that also respondent's expert has been involved, the award has been 41% of the claimed amount. And the last topic is the diversity, which we can see in our panel. Actually, it's very nice because we have actually 3 women on our panel. So when we look at the experts and tribunal members in the ICC cases, there is a huge gap between how many % of men are being appointed as quantum experts as opposed to women. And it is, as you can see, 89% in favor of men, which is unsurprising statistics, because historically the experts and usually also the partners of the advisory companies are being men, and women do not have so many opportunities to climb the ladder and are not given so much opportunities if they are not considered as high, distinct, long experts. So it is quite a difficulty to reach the level when actually the lawyers are willing to appoint a woman with less experience. And interestingly, the same actually goes for the arbitrators, for the tribunal members, where 90% are men and 10% are women. However, in this case, the statistics are improving, and actually in last 5 years, we can see that like 50% more women are being appointed as arbitrators compared to previous period. And this actually concludes my presentation, and I hope I did not get over time, actually.
Thank you very much. I found it very interesting and actually fascinating, because, you know, the figures will never let you lie, because they will show when the king is naked, in facts. And I recall, if we recall that fairy tale of Hans Christian Andersen, The New Clothes of the Emperor. And I recall a case of one of our, let's say, big guys who sued Moldova in Stockholm court. I think I've already mentioned it today, when they filed a claim of more than 100 million euro, right? And I wonder how they would reason it. Probably they will appeal to one of those methods, and from my experience, sometimes it's a matter of the same devils, which are in the details, which are the devils actually of a case. Meaning that, for instance, in the discounted cash flow methods, it's very important what the index, I don't know how to call it, the index of actualization, I don't know how to translate it, is. Because you can choose different ones, and depending on this factor on this element which you factor into the formula, the result will differ. And actually we had the report, I recall, of the Parliamentary Commission on a Saving Bank in Moldova, which they were not expert actually in Parliament, but still they were able to detect that the bank went bust, specifically or including largely because of this wrong evaluation, wrong assessment, appraisal of the assets. And it turned out that the assets which were appraised at, let's say, millions, they were worth thousands at maximum. So if someone has questions to Katerina, because otherwise she may disappear from our screen. Any question? Thank you very much, Katerina. And if you don't mind, and if the audience doesn't mind, we will go to the next absent.
Thank you very much.
Thank you again. The next virtual, but not really virtual from our room speaker, Cătălin, if you don't mind, we'll leave you for dessert. Because I've made already a number of questions to you, and I wonder what the remaining experience on that. I don't know, Victor, Ileana, if we are ready to jump to the next online speaker. Okay, super. So Evgenia PEIFFER, correct me the name, we've been discussing about big numbers, including when the claims are big in numbers. And I wonder, turning to your topic, when the arbitration court has this right, and in general, to award interim on emergency measures, how they would proceed if they see that manifestly the size, the amount is too high, is not substantiated. Interestingly, what will be in their heads and how they will do it. And the experience of the case which I was just referring of Moldova being sued in Stockholm International Arbitration Court was that the plaintiff claimed more than 800 million euros, and immediately they claimed interim measures of imposition seizures over the state assets. He was refused, as far as I recall. He was refused in the first place. But the risk was that important assets would have been seized. Just to present, Evgenia, she's from CMS team. And I bow low for the CMS team lawyers because I've participated with them in the case I mentioned in PCA. And I recall those guys, Tom and Nicolas, they were my, I think, kind of mentors because of their behavior. In court. That was years ago. I think I was the first time in PCA then in Hague. Again, we've been discussing about the beautiful palace in Hague of justice, and your colleagues were very skillful, experienced, and convincing for me to start liking it. Please.
Thank you. Thank you very much, Roger, for this wonderful introduction. Can you hear me?
Yes, we can hear and we can see you.
Perfect. So let me just share my screen in order to make sure that this is working as well.
It's working, yeah. We can see it.
Perfect. Thank you. Thank you very much. It's a pleasure and honor for me to speak today in front of this esteemed audience. And thank you very much for the invitation, Roger. I very much regret it. I cannot be in person with you today in Chișinău. You're right. The topic of my presentation today is very topical. Interim and emergency measures in international arbitration. This is an issue which has been subject to a great deal of change over the last years. Around a decade ago, international arbitration was, often criticized for not offering adequate responses to parties in emergency situations. So where time is of the essence, where the clock is ticking, emergency situations were often considered as the weak point, as the Achilles heel of arbitration. And the reason for this is obvious. If you have opted for arbitration in your contract and want to obtain interim relief in case of a dispute in front by the arbitral tribunal, you need to wait for the constitution of this tribunal. And as many of us know, a constitution of the arbitral tribunal may take time which is crucial and critical in emergency situations. Luckily, over the last years, arbitration institutions and national legislators were quite proactive and have introduced measures which are tailored to meet the pressing needs of emergency afflicted parties. So what we want to do today is, I would like to take you on a short journey to grasp the current affair, the current state of affairs. And I would like to, for you and me to have a look together at scenarios where interim relief may be of relevance, at the available options for interim relief currently, after the reforms and modernizations of the past decade. And last but not least, I would like to share with you some thoughts on the relevant factors when it comes to choosing the right option to navigate between the different options for interim relief in arbitration. And we'll finish with some key takeaways, which will hopefully help you next time when you need to decide which way to go in an emergency situation. So let's start. What are examples for scenarios where for emergency situations? And I've put a few here on the slide. I will just pick up a few which have been on my desk in the last two years and a half. Number one, a scenario where a supplier is threatening to stop delivery of goods if the counterparty does not agree to an increase of the prices which have been agreed in the contract. So you're facing this situation and you want to convince your supplier to not stop delivery, to continue delivery, and to continue delivery at the prices which have been agreed in the contract. Another case is the imminent transfer of assets to another countries. This is something that you have just referred to, Roger. A third scenario, which is very common in construction arbitration, is the risk of calling on or a payment under an on-demand guarantee, which has been given by the owner, by the contractor to the benefit of the owner. And when problems arise, when there are some delay in the construction, the owner decides to call on to encash the on-demand guarantee. And here is the question again: how can we enjoy the calling of this the guarantee, or how can we enjoy either the owner to call on this guarantee or the bank to pay under the guarantee? And just one more example, which has become quite topical in the past year, is the claim in breach of an arbitration agreement. This is something which I have dealt quite a lot with in the past years due to a law which has been passed in Russia a few years ago, which grants Russian state courts exclusive jurisdiction in cases where the dispute arises from the imposition of sanctions. So exclusive jurisdiction, irrespective of the fact whether the parties have included an arbitration agreement in their contract. And these are situations where clients of us have been confronted with Russian court proceedings, although they have agreed on proceedings before an arbitral tribunal with seats outside of Russia. So here, just to name a few scenarios, and these scenarios in mind, what are the options which are available to obtain interim relief for parties? Basically, we have three choices. Choice number one: go before state courts. This option is available generally parallel or prior to arbitration proceedings. Here, however, it is important to keep in mind that there may be certain restrictions on the recourse to state courts to receive interim relief. For example, if you have a look at the LCIA arbitration rules, you see that they say that parties can only approach state courts after the tribunal has been constituted in exceptional circumstances. At the same time, there are legislators, there are special rules, for example, in UK, in Singapore, in the Netherlands, which say that that in cases where the parties have opted for emergency arbitration, this is one of the options that we will have a look at in a second, they need to first recourse to the emergency arbitrator before they go to the state courts. So here again, state court is an option. We will deal with the advantages and disadvantages in a second, which is generally available and has the advantage, of course, that you can, the state courts are available. They are there. You can just approach them at any time. Which is the alternative number 2? Alternative number 2 is approach the arbitral tribunal. Certainly an option which is workable only after the tribunal has been constituted. Here again, the standard for interim measures and the range of interim measures depend on the applicable arbitration rules, and of course, this is something that we will address in a second on the arbitral tribunal, which will deal with the case. And last but not least, I want to share a few thoughts with you on a new option, on a quite young option, let's call it like this. This is the emergency arbitration. Emergency arbitration is an option which has been introduced in the past 15 years in almost all major arbitration rules. It started in 2006 with the AAA rules, continued with the SCC, the Stockholm rules, going over the ICC and Swiss rules in 2012, and the LCIA rules in 2014. The CIAC rules also offer emergency arbitration. So how does emergency arbitration work? Emergency arbitration means that the parties have a possibility to approach the institution in an emergency situation and ask for the appointment of an arbitrator to deal solely to render an interim relief. And the arbitral institutions which offer this option have created special rules for it, which guarantee that you will get the arbitrator will be appointed within, let's say, 24 hours to 3 days after the request was received, and an interim measure or a decision on the interim measure will be rendered within 7 to 15 days, depending on the rules, after the emergency arbitrator has received the application. So basically, we get an option to obtain interim relief prior to the constitution of the tribunal. What needs to be kept in mind here is that all arbitration rules which provide for emergency arbitration also provide a deadline within which the party which has applied for emergency arbitration needs to initiate the main proceedings. So the emergency arbitration is really just, or the emergency arbitrator is just a tool to get interim relief prior to the constitution of the tribunal. And you need to initiate the main proceedings. Otherwise, if you don't do so, and the timelines are quite strict. So we are talking about some 7 to 14 days. If you don't do so, your application will be terminated. So just an overview of the three options here again. So an emergency arbitration under the ICC rules starts with an application. Within 2 to 3 days, you get your emergency arbitrator who will deal only with your application. So the emergency arbitrator will not be a part of the tribunal to decide on the main proceedings. And within, after the emergency arbitrator has been appointed, there is a short case management conference where the parties have the possibility to agree on very, very short deadlines for the submissions. Sometimes, but not always, there is also an oral hearing. But as you see here on the timeline, everything in a very condensed manner so that the arbitrator can render an award within 10 to 15 days. And after this award is rendered, basically it is valid, an award or an order. Basically, this order is valid until the final award in the main proceedings. However, once an once the arbitral tribunal in these main proceedings has been constituted, it can revise or cancel the order rendered by the emergency arbitrator. And by contrast, if we just look at the option arbitration, you need to first file your request for arbitration, you need to wait for the appointment of the arbitral tribunal, and only after it has been constituted you can rely on the arbitrators and request them to order an interim relief. By contrast, the state courts are always there for you, and there you can apply and get interim measures generally at any time. Just a brief look on the requirements for granting interim measures, and this is something that you have also referred to, Roger, in the introduction. So basically, when it comes to the requirements for granting interim measures, one needs to keep in mind that there are no definite criteria. So there is no definite list of criteria. Rather, the arbitral tribunal or the emergency arbitrator will either leave it up to the parties to agree on one common standard to be applied, or it will just pick those criteria which it considers more relevant. And here I have just listed a few criteria which are often referred to, relied upon when arbitral tribunals and emergency arbitrators decide on applications for interim reliefs, which are, of course, they need jurisdiction, the urgency, which means in case of an emergency arbitrator that the party cannot await the constitution of the arbitral tribunal. We need an irreparable harm. And here it's also important, and I think this was the reason why the application in the Moldova case to which you just referred to was rejected. The question is how to interpret the requirement of an irreparable harm. In many national jurisdictions, irreparable harm is only seen in situations where the harm cannot be compensated, cannot be monetarily compensated. In international arbitration, there is a tendency to a more broader interpretation of the term irreparable harm. So often one would see arbitrators considering sufficient if there is a serious or grave harm, even if it's compensable by a monetary relief. And if I recall correctly, in the Moldova case, the arbitrator applied a quite strict standard and said that it does not see a harm which cannot be later compensated by monetary relief. So here you see there is a, let's say, a certain uncertainty, which also gives flexibility for the parties when it comes to the standard for granting interim measures in arbitration. And of course, arbitrators would also look on the prospect of success on the merits, on the proportionality, and they will make sure not to prejudge on the merits. So far, so good. So let's have a look at some criteria when it comes to choosing between the available options for interim relief. And here I have just put together a few criteria which I consider important and relevant in emergency situations. First one being speed. Of course, this is an argument for many state courts, especially for state courts which function fast and efficient and are readily available. In Germany, for example, I have experienced courts granting interim relief within 48 hours. Basically, you can also get interim relief on the weekends. There are special hotlines designed to serve the needs of the parties in emergency situations, which make sure that you reach the court on holidays and on the weekend. So here, on the one hand, we have the availability of the courts, which do not need to be constituted, which is a clear advantage, and the speed. However, in some countries, the speed may differ, so it can be questionable if the state courts will be always the best choice when it comes to looking for a forum where I can speedily obtain interim relief. And of course, the arbitral tribunal, there is the downside that it needs to be constituted. When it comes to the emergency arbitrator, it very much depends. So you can rely on obtaining a decision within 10 to 15 days, which I would say is quite fast. But here again, the decision between interim arbitration, between emergency arbitration and state court will depend on the speed which I can expect from the state courts. Neutrality, I would say this is clearly a point for the arbitral tribunal and emergency arbitration, and can be particularly an issue if measures are required at the seat of one of the parties. Confidentiality, here again, I would say a big plus for arbitration beat by an arbitral tribunal or emergency arbitration. The expertise can be an advantage or is an advantage of arbitration, and certainly an advantage when it comes to obtaining interim relief by an arbitral tribunal. When it comes to emergency arbitration, the institution they make sure that the emergency arbitrator appointed is not only experienced enough to deal with the situation and with the very condensed timetable, but also has expertise in the relevant industry and subject matter. And for the state courts, well, it goes without saying, here the expertise of the deciding judge in the industry is uncertain. You may be lucky or not. Range of measures. Here, when you approach state courts, you can only apply for the interim measures which are provided for in the procedural law. If you go to an arbitral tribunal or to an emergency arbitrator, you are generally more flexible. There is no defined set of measures unless there are mandatory provisions in the national law, which, for example, can make it possible that although German courts have so far not rendered an anti-suit injunction to protect an arbitration agreement, that international arbitral tribunal seated in Germany might do so in order to protect the arbitration agreement of the parties. Requirements for granting interim relief. Here I would say we have a plus and a minus everywhere. It depends what you're looking for. Under national law, we have defined standards, which makes them more foreseeable, but less flexible. And in arbitral tribunals, we have no defined standards. So it very much depends on the arbitral tribunal, which gives flexibility and also offers both the applicant and the respondent chances to present the best arguments for their position. Ex parte decisions. This is clearly an advantage of state courts. Arbitral tribunal and emergency arbitrators will not, or only rarely, go for ex parte measures, meaning render an interim relief before having heard the responding party. State courts, at least in Germany, will be very hesitant to do so, but if the emergency situation requires to do so, they will render an ex parte decision and then grant the responding party an opportunity to be heard and to present its arguments. Measures against third party is against an advantage of state courts and a disadvantage of arbitral tribunals and emergency arbitrators, because certainly arbitration only grants the tribunal competence over parties to the arbitration agreement. And last but not least, the issue of enforceability. Certainly state courts have the power which arbitral tribunals do not have. So once they render interim measures, there is no national enforcement is required. Whereas for measures rendered by arbitral tribunals and emergency arbitrators, a national enforcement is necessary. However, one needs to keep in mind that according to statistics which have been presented, for example, by the ICC some 3 years ago on their experience with emergency arbitrations, it seems that there is a very high likelihood of voluntary compliance of the parties, and this is also my experience, with orders rendered by arbitral tribunals and emergency arbitrators. Why is this so? Well, there are a few very simple reasons. First of all, if you don't comply with an order, this may give rise to contractual liability of the non-compliant party, because by agreeing to the arbitration rules, you also agree to comply with orders rendered by an arbitral tribunal or emergency arbitrator. Second of all, not complying with interim measures leaves a bad impression on the tribunal, and it is questionable if you want to be perceived as the non-constructive party already at the outset of the proceedings. And last but not least, non-compliance with interim relief can have an impact on the cost allocation in the final award. So let me now come to the end and just summarize a few key takeaways on interim relief in international arbitration. When you are in the drafting phase, I suggest that you consider the following issues. First, how important do you think that interim measures could potentially become in case of a dispute? What is the availability of interim measures before state courts in the relevant jurisdictions in terms of speed, neutrality, and substantive standards? Are state courts reliable when it comes to interim relief? If they are reliable, you may think of opting out emergency arbitration provisions, which may be included in the arbitration rules that you want to take for your next contract. When you are the party which considers applying for interim relief, first weigh carefully the pros and cons of the available options, so which of the three ways to go, and be aware, and this is also reflected in the statistics, that emergency arbitrator requests and also interim requests by arbitral tribunals are more often refused than granted. So consider the cost risk, and when applying for emergency arbitration, also consider the short deadline for commencing the main arbitration proceedings. If a request is granted, however, the other party is very likely to comply voluntarily. And another advantage of an emergency arbitrator decision is that, and this was also reported in this in many statistics of arbitral institutions, is that the reasoning of the emergency arbitrator has been in many cases perceived as an incentive for the parties to reach an early settlement. If you are the responding party, keep in mind that requests for interim relief are often rejected, so you shouldn't surrender without a fight. And think of the flexibility that you have when it comes to the standard for granting interim relief, especially when it comes to urgency and irreparable harm, which are often denied. And last but not least, if interim relief is granted against you, think twice before deciding not to comply. I hope this was helpful for you, and now pass the floor back to you, Roger.
Thank you, Evgenia. We've been talking about the wise man approach in arbitration, people who can give you not only assistance but also advice, and I found several wise men advices here. I have a question before anybody else has a question to you. That's a question from the practicing attorney. You've referred, interestingly, to the drafting stage, right? The question is, as long as you said that in international arbitration there is no exclusive, definite, you said, list of criteria for imposition of interim measures, do you think that putting kind of them in the contract will work? What's your take on this? What's your experience, if you have an experience on that? Because that would be very interesting. And indeed, in National Court, you open the articles of the Civil Procedure Code, and you have a list. Even if it's not exhaustive, it's still a list which is played and sometimes misplayed by the judges and the participants. How about the international arbitration? Will it work, in your view?
Well, it's a very good question, Roger. To be honest, I have not so far faced a situation where the parties had ruled on this issue in their contract. And I can imagine that parties will be very, very careful in doing this, because you never know in which position you will be in an emergency situation. Will you be the applicant or the respondent? And so, therefore, I think this is something which one can think of, but I'm not sure if I would be the one to advise to put a list of criteria which should be considered relevant. In my experience, so far, actually, in almost all cases, the parties had reached an agreement on what was relevant criteria for the tribunal.
I see. Thank you. Serghei, Cătălin?
I have a question. Evgenia, you mentioned the possibility of using the services of an emergency arbitrator as provided by some institutional rules. What if, and let's go beyond the fact that these kind of orders are usually voluntarily complied. What if the national law of the Lex Arbitrii, for example, does not provide anything, does not regulate the institution of emergency arbitrator? In this case, the order, the emergency arbitrator, for the purpose of the law, is it considered an arbitral tribunal or something less? Or not at all? We have this situation in Moldova where we do have emergency arbitration services, or the possibility to use these services even at CACIC. At the same time, the national law says nothing about that. So the question is, are they arbitral tribunals for the purpose of the law?
Yeah, thank you for the question, Serghei. That's a very interesting point. So, in Germany, interestingly, we also don't have any national rules on emergency arbitration. So this institute is not at all addressed in the National Procedure Code. However, according to the leading practitioners and what is so far discussed in the legal literature, the fact that there is no rule does not close the door, but rather makes it possible for an emergency arbitrator to act. Although you're absolutely right. So, I mean, let's put it like this. In Germany, we don't have any rules. There are other countries. And if I see correctly, these are, for example, Greece or China, or I think even Argentina, Italy for I think they're just for now reforming the law, where the national law says that the tribunal is not entitled to render an emergency arbitrator is not entitled to render a decision. If we don't have this situation, but a situation like in Germany or understand in Moldova, I would see good arguments to consider the emergency arbitrator as a tribunal. This is the way it is done in Germany. Although it may play a role in which form the emergency arbitrator renders a decision. So, for example, in Germany, there are discussions if there may be a difference between decision rendered in the form of an award or decision rendered in the form of an order. Yeah, the more it goes into the direction of an award, the higher the chance, I would say, that it's treated as an arbitral tribunal. This is the situation in Germany. When we look at the issue from an international point of view, for example, if emergency arbitrator orders are considered awards in terms of the Euro Convention, I understand the predominant literature to say that this is not the case, since an award under the Euro Convention must be final and binding, and an interim award is not final and binding. But in my view, I would consider an emergency arbitrator as a tribunal for the purpose of national law. I don't know how the situation and how the discussions are now on Moldova, and I would appreciate your thoughts on this.
There are no discussions here yet.
Okay. Mm-hmm.
So I think we're starting the discussion right now, right here. So we're waiting to have a case where this issue might be debated. Thank you.
Mm-hmm.
If I may jump in. Hi, Evgenia. Good to see you again.
Hi, Katerina. Nice to see you.
Before raising my question, I have a comment on Sergiu's question earlier and your response to it. I hope I will not complicate Sergiu's pending case. So I would agree with you that the emergency arbitrator should count as a tribunal for the purpose of national legislation, at least from the perspective of Romanian law, and I would assume also Moldovan law. But imagine that since there is no legal provision in the internal law dealing with this situation, and you have an arbitral clause which speaks, for example, of 3 arbitrators making the tribunal, then it becomes complicated to appoint an emergency arbitrator pursuant to the arbitration rules of the Court of Arbitration, which presumably speaks of 1 person, whereas the clause speaks of 3 persons dealing with any dispute between the parties. So just as a potential complication, I'm not sure if you have any views on that.
Yeah, that's a good point, Cătălin, but what I mean, on the one hand, we are dealing with a situation where the parties have opted for, let's say, 3-member arbitral tribunal on the one hand. On the other hand, they have chosen arbitration rules which provide for emergency arbitration.
I agree. I also have another question which deals with one of my pending cases. I hope I don't interfere with it, since by the time this conference will end, I will have received the decision on my application. So it is generally accepted that a claimant can apply for attachment measures, for example, also sometimes before the tribunal, it is also generally accepted that at least a respondent can apply for security on costs. I wonder whether you have seen or ever heard of the situation where a claimant applies for security in relation to its claim plus its costs, because it expects the respondent not to pay at the end of the arbitration.
Okay, interesting. To be honest, I have not experienced this situation yet. However, yeah, that's interesting. However, I can imagine that a similar standard would be applied by the tribunal as in the situation where respondent would apply for security for costs. Or what is your experience on this?
Well, it's clear that we have been unable to show any precedents for this, and the other side has been very upset with the idea, the concept of making such an application. On the other hand, I believe, and we have argued, as you said, that the same test and standards should apply to the application made by a claimant, especially since it is customarily accepted that a claimant can apply for security in the sense of attachment measures. So once we accept that, why should not the claimant be in a position to apply for other kinds of security, especially since, as we have seen in your presentation earlier, and once again I agree with that, there is no limit as to the range of interim measures that a tribunal should be able to order. So once we accept the principle that you can apply for attachment measures, then you should be able to apply for other kinds of interim measures providing the same kind of effect, security in essence.
Yeah, you're right. And here again, we are facing a situation where the lack of certainty can be both a curse or a blessing.
It's true. Thank you.
Yeah, this is indeed what we appreciated, that a threat can become an opportunity. We've been discussing that, Evgenia, before you came in. Thank you. If there is no other questions to Evgenia, thank you very much. I'm disappointed to stop this discussion of yours because it was very interesting, and everything which relates to interim and expeditious matters are very interesting because this is part of our life. Our life is becoming more and more expeditive, and I think that shortly or irreversibly, sooner or later, any proceeding will be judged through the lens of time, because it's time value of money, it's everything which relates to times nowadays. So emergency proceeding will become a rule, I think. Thank you.
Thank you very much.
Întorcându-ne la dulcea noastră limbă română, vreau să...
So I return to Romania and I come back to Cătălin. I would like to say two things. I didn't know Cătălin prior to this event, but now it's very easy. If you want to find a good specialist which is active internationally, you search two databases, two Chambers 500 or the 1000. So I checked that and I found Cătălin. And I was asking Victor, who to invite from Romania? And we were checking the big companies. And we understood that we can invite Cătălin because Filip and Company became one of the biggest lawyers company in Romania. And Cătălin is leading the litigation and arbitration department. And if you open the database, you see Cătălin is #1. So Cătălin, you have the privilege, but also a serious responsibility here. But also I can say that you are our colleague. Because you participated in AmCham, yes. In the CCRE, no, but in AmCham, yes. Okay. Welcome to Moldovan AmCham. If you remember the questions, please start to reply. You are the last in the list.
Celor temerari din sală care au rămas până la urmă, știți, Cătălin este o piesă de rezistență din arbitrajul și, în general, din dispute resolution din România. Nu o să vă pară rău că ați rămas până la urmă. Te rog.
Mulțumesc, Roger.
So thank you very much, Roger. I'm honored to be here, and thank you very much for inviting me. I am actually lucky because whatever you say about this subject, we will definitely always support in the practice. So I know that I am the last one to talk, but I want to tell you about a study that was done in Israel about the decision for the conditioned release of the detainees. And this actually was an amazing example. And, you know, the chances to take a good decision before the lunch were close to zero. And after the lunch, much higher. I'm saying this because I know that everyone is waiting for the lunch, but please bear with me. I would like, first of all, to thank the European Union and the United States for their support, because in Romania, and I'm sure also for you in Moldova, we received so much support. They gave us a structure, they gave us a model to follow. And, you know, coming back to, let me give you an example. In parenting, we have this principle of giving to the children a structure, an example from the parents. And this is what actually European Union and United States did for Romania and in Moldova also for, first of all, the fight against corruption and reform of the justice sector. And I think in that sense, our role is to take on board the responsibilities. But we will see that people actually do not always agree with what is happening, and it is oftentimes difficult to take as a personal responsibility. And when you face a challenge, sometimes we want to just close our eyes and say, no, with this question, don't come to me. This is not my case. And oftentimes we don't know how to react. But let me tell you that in my personal experience, I had different situations and I made some conclusions that I want to share with you in my presentation. So the personal experience showed me that it's difficult. You never know how exactly to act, but in arbitration, a long time, at the beginning, the specialists preferred not to touch the subjects related to corruption, because they were somehow saying the same thing. It is not our business. It is not our problem. And they preferred to ignore that because it was not from their main activity, from their main list of activities. And nevertheless, there's always someone who is willing to take on board the responsibility to be the first. And the Swedish judge once said, I will not accept in my practice to take on board the cases where I can smell corruption. And you know, this after this decision, a few cases were exactly the same. And we actually to discuss some things that we prefer to ignore previously. So in that sense, the arbitrators, they are not coming to make to take on board criminal cases. They have a mission, and their mission is to preserve public order by using those tools that are available to them. And one of the arguments that were brought in that sense is that arbitration specialists, they do not have a mandate to bring witness, to forcefully manage the samples that are probes and evidences. So it's the only thing they can do is make the conclusion that there is a corruption situation. And how this is manifested in arbitration? I met all kinds of situations in my experience. For example, in an investment case, sometimes they speak about the corruption in the targeted country where he actually was exposed to some big damage because he refused to pay some bribes. And the state, state employees actually even made some actions of revenge, and that is why the foreign investor actually had to suffer a lot. So in this case, of course, the trial is getting very complicated because it's about bringing proofs. And in this case, you have to have video proofs, you have to have audio proofs, you have to have documentation, but it's quite difficult. And the bribing is one of the biggest challenge in this process. And sometimes it can happen that an agreement was obtained actually through bribing. And this is also a situation that is quite often encountered mainly in the Eastern communities, unfortunately, although, of course, this happens all over the world. And we discuss also of corruption of arbitrary experts or also lawyers. This is rarely encountered, but it's nevertheless possible. How do we recognize corruption? This is a very difficult question. There are cases where you can see it directly, very easily, but sometimes there is, for example, World Duty Free Center against Kenya. The legal representative of the complainant actually made a declaration about how he actually gave a bribe to the president of Kenya, and he was mentioning that this is the only way you can function in Kenya. And I mean, this is a direct case of corruption, and it's of course, extremely rare case. Usually, the money laundering and corruption is actually an activity that is very well hidden. So, how can we recognize it? I think oftentimes it's about us thinking about the proverb, Latin proverb, without a fire there is no smoke. And I think each of us, we can use a series of tools like International Convention, Council of Europe tools about how to fight corruption, how to define and how to fight corruption. Also, I recommend you to there is an agreement made in Basel about corruption and money laundering. And there are also a series of red flags to be taken into consideration because they already, these cases already happened. And I'll give you some concrete examples. So using intermediary for payments, usually people that don't have competencies, it's about weird payments, the identity, using identities in fiscal paradises. So the risk for the country in Romania and Moldova, it has to be taken into consideration. So you have to be suspicious about the circumstances where these things happen. mainly when you involve in a relationship with a state, at the level of a state. Okay, another question that is asked is about a tribunal, it's about a court that has the obligation to investigate corruption in case there is no complaint. Of course, if there is a complaint, it's obliged. The arbitration is obliged to analyze, to assess the problem. But if none of the parts complain, what the court can do? So from one side, you can consider that a court that is investigating on its own something is actually overpassing the mandate. So it's a too high appetite in this case. But the international practice shows that usually a court is not involving, although the general practice is actually encouraging that, because the court has the role to also preserve public order. And one situation was in Uzbekistan, where it was Metal Tech against Uzbekistan, where at the final audition, the legal representative of the complainant declared in the court that he paid millions of dollars to some consultants. And of course, that raised a lot of questions. And of course, somebody from, the person was requested to make explanations about the payments that he did. And by the end of the day, we will see, by using the theory of red flags, the conclusion was that it was a case of bribery. A big problem in this context, in the context of corruption, is that they are very well hidden. And they are sometimes based on very sophisticated methods of, hiding it. Some people are extremely creative when it comes to this. So it's also about who recognizes that there is a corruption there. So then let's speak about the tools that when the arbitration has the opportunity to use those tools. So I don't know if the lawyers can use the same approach, but the arbitration, like in the case of Metal Text, to request documents, to request proofs, and even it was a discussion that it would be great to employ an independent expert that would make a forensic assessment. And of course, there is always the possibility for adverse influences against that party, and that's another thing to be considered. Another thing that was discussed with practical involvement was the probe standard. How heavy should be the evidences in order to prove the corruption? And in the Constitution, I think in the Republic of Moldova is the same, it's to make reference to the conviction of judges. But in the West, there are balance of probabilities approach or other approaches. And it says that if there is a probability to have corruption, then it should be assessed. Another very high standard is
Asta înseamnă că trebuie să nu existe niciun scenariu alternativ plauzibil de explicare a faptelor. Și să vă dau un exemplu. A existat un caz la Tribunalul de Arbitraj Sportiv, se numește Bin Hammam împotriva FIFA. Domnul Bin Hammam era un candidat la președinția FIFA care i-a cerut vicepreședintelui FIFA de la momentul respectiv să organizeze o întâlnire specială cu reprezentanții unei asociații de fotbal caraibene, să-i cheme la o întâlnire specială, unde domnul Bin Hammam a ținut un discurs, după care a părăsit sala, iar vicepreședintele FIFA, care convocase întâlnirea respectivă, le-a spus delegaților după aceea că în sala de consiliu vă așteaptă daruri. Când s-au dus în sala de consiliu, fiecare a primit un plic cu câte $40.000. S-a făcut dovada că acele plicuri veneau dintr-o servietă din biroul vicepreședintelui FIFA care convocase întâlnirea. Și tribunalul a trebuit să decidă dacă acei bani veneau de la domnul bin Hammam, care ținuse un speech și plecase din sală. Și tribunalul a spus așa, este probabil că banii au venit de la dumnealui. Dar nu pot să exclud alte variante, precum că vicepreședintele FIFA a decis el să câștige un favor, să zicem, de la acești delegați și a decis de unul singur să plătească acești bani. Sau că au venit banii de la o terță persoană. Sunt improbabile aceste variante, dar posibile. Și iată că aplicând un standard de probă de tip penal, beyond reasonable doubt, a ajuns să excludă ceea ce a considerat el însuși ca fiind probabil să se fi întâmplat. Care sunt consecințele constatării corupției într-o procedură arbitrală? Depinde cum se invocă. Dacă ea este invocată de către reclamant, cum s-a întâmplat în cazul IDF versus România, dacă, evident, se constată că ea există, se acordă despăgubiri. Altfel, de cele mai multe ori, pârâtul este cel care invocă corupția pentru a se apăra de cererea reclamantului și, într-un asemenea caz, este îndeopște acceptat că nulitatea este cea care intervine. S-a discutat mult dacă nu ar trebui să existe și aici este o diferență între corupție și celelalte forme de criminalitate. Dacă frauda sau spălarea de bani se întâmplă unilateral, o singură parte face chestia asta, corupția are două părți. Unul oferă și unul primește. Și nu e o vină exclusivă în general, mai ales când discutăm de relație, indiferent dacă e cu stat sau între particulari. Și s-a pus pe bună dreptate întrebarea, e corect să sufere numai unul, adică să zicem reclamantul privat care cere despăgubiri de la stat, e corect să îi se respingă pur și simplu cererea când de fapt și statul a beneficiat sau funcționarii statului, cum a fost cazul președintelui Keniei. Da? Să beneficieze deopotrivă de mită, dar și de respingerea acțiunii și nu există un răspuns care să fie universal valabil. Iau din nou exemplu Metaltech, unde tribunalul s-a confruntat cu aceeași întrebare și a decis ca, deși respingând acțiunea, să împartă costurile de judecată, costurile de arbitraj între părți. A fost o măsură minimă pe care a putut să o ia într-o asemenea situație. Trebuie să aveți în vedere că și închizând ochii la o asemenea problemă nu înseamnă că o hotărâre arbitrală va rămâne în picioare. Practica recentă a instanțelor, atât în Franța cât și în Anglia, și o să revin imediat cu la exemplu, este că chiar dacă tribunalul arbitral nu se uită pe probleme de corupție, chiar dacă nu se invocă problemele de corupție, hotărârea va putea fi anulată dacă în fața instanței se face dovada, chiar cu probe noi și cu argumente noi, a existenței corupției. Așadar, nici părțile și nici tribunalul nu scapă de problemă pur și simplu închizând ochii. Și vreau să vă dau un exemplu recent de la, apropo și de motivări. Eu sunt fascinat de motivările pe care le văd în dreptul englez, în general și în dreptul american. Vă recomand să citiți motivarea unui judecător care de curând a decis să anuleze hotărârea unui tribunal arbitral într-un caz împotriva Nigeriei, e pe internet acum. Un judecător englez așadar, era vorba de un tribunal arbitral care era format din niște arbitri extrem de experimentați, tot din vest, și au fost mai multe lucruri care trebuia. Am văzut și interviuri ale președintelui Tribunalului Arbitral care a spus așa: am simțit un miros foarte puternic de neonestitate, dar nu am știut de ce. Și într-adevăr, a spus și judecătorul, nu am ce să reproșez neapărat tribunalului că nu a văzut corupția aici, pentru că nu erau toate elementele în fața lui. Dar în același timp îi reproșez că nu a căutat să afle și să dă adevăr, adică lipsa rolului activ, nu a căutat să afle ce s-a întâmplat cu adevărat acolo. Și printre lucrurile cu care s-a confruntat tribunalul arbitral, apropo și de modul de selecție a avocaților, era un non-combat, aproape lipsă totală de apărare din partea avocaților, mai ales la faza de quantum. Imaginați-vă că era un proiect în care exista doar pe hârtie un plan și s-au dat despăgubiri de 11 miliarde de dolari, dintre care 5 miliarde erau dobânzi. Și la faza de quantum, când s-au certat părțile, absolut toate argumentele invocate de Nigeria erau pur și simplu nerelevante irelevante și puerile, adică lipsă de apărare totală aproape într-un asemenea dosar. Iar Tribunalul Arbitral s-a comportat ca într-un sistem pur adversarial în care a zis e datoria părților să prezinte argumente în fața mea, nu e treaba mea să suplinez lipsa de apărare a părții care, deși era evident că nu se apără acolo și în cel din urmă s-a acuzat corupția avocatului, e foarte complicată povestea, dar cert e că tribunalul n-a făcut nimic. Și a zis, dacă nu-i treaba lor, dacă nu se apără bine, ceilalți au avut experți și avocați foarte buni și le-a dat în integralitate 11 miliarde cât au cerut. Și vă recomand să citiți din nou motivarea judecătorului englez în care discută despre pata mare de reputație asupra arbitrajului pe care o asemenea hotărâre o provoacă și de ce nu este acceptabilă, pentru că trebuie avut în vedere verticalitatea procesului și reputația, repet, a instituției în sine arbitrajului. Și în fine să vă împărtășesc câteva experiențe personale. Am avut ocazia să văd corupția expertului în arbitraj. Expertul dintr-un proiect în care eram implicat a venit și a cerut mită clientului. Și clientul a venit la noi și a întrebat ce să facem. Reacția pe care am avut-o a fost așa: dacă mergem să facem plângere acum la organele penale împotriva lui, că nu e, sau să fie urmărit și așa mai departe, o să se suspende tot. Ceea ce propunem este să informăm partea adversă și tribunalul arbitral cu privire la ce s-a întâmplat. Întâmplător, expertul respectiv nu era un arbitraj care se desfășura în limba engleză și un criteriu de selecție a experților era să știe engleză. Și am observat că expertul respectiv nu prea știe engleză. Și am propus părții adverse și tribunalului, informându-i cu privire la ce s-a întâmplat, o soluție pe care am considerat-o elegantă și rapidă, să fie ascultat expertul la limba engleză. Și a fost ascultat expertul, s-a constatat că nu știe engleză și a fost eliminat din proces și înlocuit cu un alt expert și s-a rezolvat problema așa, fără să se mai ducă lucrurile în zona penală. Mi s-a întâmplat să mă confrunt cu corupție a judecătorului în legătură cu un arbitraj. Și aici am suferit pe propria piele, să zic așa, în România. Era un contract și se leagă un pic și de prezentarea domnului Crețu de mai devreme, interacțiunea dintre insolvență și arbitraj. Un contract în care debitorul aflat în insolvență avea pretenții împotriva clientului meu. Un contract care avea clauză de arbitraj și care mă așteptam să ajungă în mod normal în fața unei instanțe arbitrale, nu în insolvență. M-am dus în fața judecătorului și am arătat că în trecut luase o decizie, era o discuție pe competență, la cine trebuie să meargă un asemenea litigiu. Și am arătat o decizie a lui, în care zisese la mine trebuie să fie o asemenea dispută, care a fost desfințată de Curtea de Apel, care i-a spus nu, la tine trebuie să meargă în arbitraj. Și am zis, vă rog, nu luați aceeași decizie, că uitați, Curtea de Apel a decis deja cu privire la decizie anterioară a noastră că nu e corect. S-a amânat pronunțarea pentru vreo 2 sau 3 luni. N-am știut, nu mi se spunea de către nimeni, nici care e pronunțarea, sunam la arhivă, nimeni, nu există, încă nu există, iar clientul s-a trezit deja cu banii luați din cont, deci hotărârea redactată și banii luați din cont și executată la momentul la care noi abia eram informați că s-a întâmplat ceva. Epilogul este că în cazul respectiv a trebuit să n-am avut absolut nicio probă, doar ni s-a întâmplat acest abuz. N-am știut și nu am mers la momentul respectiv să facem plângere la procurori. Clientul a trebuit să accepte și să facă un fel de settlement până la urmă, că i s-au luat banii, care erau foarte greu de luat înapoi din insolvență. Iar judecătorul, după 1 sau 2 ani, nu mai țin minte, a fost prins în timp ce fugea de procurori sărind șinele de tren și acum servește o pedeapsă de 22 de ani de închisoare pentru altceva, unrelated. Mai sunt și alte experiențe legate de corupție. Una care ține de insuficiența probelor. Am fost implicat într-un dosar în care, din nou, am simțit acea suspiciune ca avocat, da? Și te întrebi să pun clientul să facă niște cheltuieli, că o cale pentru a verifica dacă chiar, neavând instrumentele procurorilor. Repet, ca avocat nu pot să sap după lucruri în același fel în care o pot face organele penale. Dar un mod de a afla mai multe informații este, de exemplu, să angajezi un investigator, un expert forenzic, care să se uite pe niște lucruri cu niște ochi calificați. Asta înseamnă niște costuri pe care trebuie să și le asume clientul pe baza unei suspiciuni, a unui hunch pe care l-ai tu și care nu știu unde o să ducă. Și am decis, plus că am avut această suspiciune la un moment la care deja trebuia să ne formulăm apărările. Ce facem? Invocăm corupția când nu avem probe? Am decis să o facem și cred că am luat decizia potrivită. Pentru că odată ce invoci lucrurile astea într-un arbitraj, asta îți dă posibilitatea să ceri informații, de exemplu, așa numitul document production, să ceri informații și documente de la cealaltă parte. Dacă nu invoci argumentul, n-ai cum să ceri documente, că ele nu mai au legătură cu arbitrajul respectiv. Probațiunea va fi întotdeauna imperfectă și deci, deși este o decizie care, evident, trebuie luată cu mare atenție, de balansare de costuri, cu multe alte aspecte, practica mi-a arătat că, cel puțin în cazul ăsta, a dus spre lucruri pozitive, pentru că a fost întărit cazul de-a lungul, pe parcursul lui, prin probele pe care am reușit să le obținem în felul ăsta. Cam asta am de împărtășit. Vreau să răspund și la o întrebare care a venit în cursul prezentărilor de mai devreme, legate de modalitatea de selecție a avocaților de către România. Am cuvinte numai de laudă despre sistemul actual de selecție a avocaților și vă recomand să îl studiați. Am auzit cuvinte de laudă din partea avocaților externi cu care am intrat în consorțiu, încercând să câștigăm mandate acolo. Este o bătaie uriașă de cap pentru avocați, dar pentru România este un sistem foarte bun. De ce? E o combinație ideală de punctaj tehnic și punctaj financiar și se pune o presiune enormă pe ambele aspecte. Are loc, se face selecția, de exemplu, în două leere. Într-o primă fază se selectează un panel de firme și orice mandat ulterior se relicitează financiar între acele firme. În selecția inițială se asigură că se ia punctaj tehnic cât mai mare, deci 60%, în panelul trecut au fost 70-30, acum tehnicul are 60%. Dacă vrei să ai punctaj maxim, te obligă, de exemplu, ca 8 din 10 avocați să aibă minim 7 ani vechime în profesie, ceea ce e foarte mult, adică foarte puțin junior dacă vrei să ai punctaj maxim, te obligă să ai arbitraje exit sau un citral câștigate, participare în arbitraje exit sau un citral a tuturor avocaților sau a unui număr, de fapt, relevant de avocați din echipă și separat bătaie financiară, care e nu o dată, ci de 2 ori. Și asta e, mă uit la selecția avocaților de-a lungul timpului de către România s-a îmbunătățit foarte mult, adică panelurile arată mult mai bine în ultimii 5-6 ani decât ce existau în trecut, unde era mult mai pestriți și modul în care ajungeau mandatele mai netransparent. Așadar, se poate, comparând cu situația Nigeriei de care am vorbit mai devreme, unde n-au avut avocați externi, au avut niște avocați nespecializați în arbitraj internațional și s-a ajuns la un non-combat total și la hotărâri de 11 miliarde cum s-a ajuns. Părerea mea e că e importantă investiția în avocați buni, în arbitraje pentru orice stat și că în același timp are sens un sistem sofisticat care să pună presiune și pe onorarii, pentru că până la urmă sunt limitate resursele bugetare.
Un comentariu, dacă sau...
Înainte de a face, Sergiu, un comentariu, eu am vrut să vă rog, schimbăm un pic macazul și în loc să am eu cuvântul de închidere, să rog cineva din sală să aibă cuvântul de închidere, ca să vedem care sunt lessons learned, așa, din prima, dar poate fi oricine, din colegii mai grizonanți, Dirty Soldiers, da, nu știu, Eliana, Andrei, domnul Vas, nu acum, mai întâi Sergiu, da, sau din cineva din generația nouă, apropo, dacă vrea tot să aibă un input, pentru că pe mine personal și cred că pe noi în general ne interesează. Ne interesează care e take-aways, ce ați luat acasă din asta, ca noi să știm mai departe ce mapăm și ce transmitem.
mi-a plăcut temele așa cum le-ai abordat. Mă gândeam acum la standardul de probațiune, da? În procedurile arbitrale, atunci când se invocă acte de corupție, a zis că cel mai probabil nu ar fi probabilitatea, preponderența probelor, da, the balancing of evidence, da? Pe de altă parte, stau și mă gândesc că evident că nu ar fi prea înalt standardul de probațiune din penal, dincolo de orice dubiu rezonabil. Este o practică deja la ICC cel puțin, unde se încearcă a se folosi un standard un pic intermediar între astea două, da, clear and convincing evidence, da, un probatoriu clar și evident, ceva de genul ăsta. Probabil, posibil aceasta ar fi o soluție așa, care să-ți facă munca mai ușoară avocaților, dar în același timp să nu fim la același nivel cu preponderența probelor. Există și acest nivel intermediar. Toate trei cumva provin din teoria și practica din Statele Unite, da, unde în civil e cel de balance of probabilities, în penal e beyond reasonable doubt și cel de mijloc este în civil când se invocă niște lucruri delicate, cum ar fi corupție, cum sunt cazuri de încredințare de minori, sunt cazuri mai delicate, fraudă și așa mai departe. Acum, părerea mea personală, în practică există toate formele posibile, de-aia spuneam la început că orice aș spune în legătură cu problema corupției, voi găsi hotărâri arbitrale și comentatori care să susțină ceea ce spun. În practică se găsesc deci toate variantele. Părerea mea este că cel mai potrivit este cel mai jos. Există comentatori care propun și mai jos, având în vedere dificultățile de probă în cazul corupției. Și luând exemplu pe care l-am dat mai devreme cu tribunalul, cu FIFA și cu tribunalul sportiv, eu unul nu aș fi acceptat să nu recunosc corupția acolo și nu mi-e clar dacă
And for me, it's not clear if by applying clear and convincing evidence, I would have reached the conclusion of the standard below of the standard above. So it's about corruption and the risk in our country, the risk of corruption is higher, and the more restrictions there are in the rules, I think the more we give them the floor to avoid that. But when we discuss the probation standards, I don't see any connection between the intimate conviction that is a method to take the final decision and probation standards. I don't know why some of the Eastern Europe are bringing those two together. The consultancy that was made in the years 2000, I think, by the way, it was a case of Metalclad against Mexico. And in that case, the investor actually employed two local people to consult him in obtaining some kind of an authorization that was half a page. And he paid $1,300 for that. And at that time, it was really a big amount. I don't remember what the court commented on that, but in cross-examination, one of those consultants were invited, and the lawyers just brought them down. I mean, they asked, actually, I'm sorry, it was not 1,300, it was 300,000. So they asked 300,000 you took for that, and the expert said, yeah, but it's I'm an experienced consultant, and for me, this is just so clear that this is just a bribery or traffic of influence or whatever, but it was definitely something unclean. To speak about the probation standard, there is also a problem of indirect probes, but this again comes to the red flags. more and more you can prove the corruption with red flags. And in the previous cases that I was describing, we had the recognition of the fact that some payments to the consultants were made, but then the conclusion, final conclusion was that, for example, in that specific case, was that the consultant was actually a relative of the Prime Minister, and the money went to the offshore paradise by the end of the day. So it was enough evidence in order to make conclusion that that was a very dirty case. Even if we apply a very high behind reasonable doubt standard, we can come to the conclusion that there was a corruption case based on the presumption aspect, if we have very strong evidence. By the way, about probation, we had a case in Moldova when Charles Zarif, the complainant, actually complained about corruption in the duty-free cases, if you remember. And I remember from the final decision, the respondent, there is no evidence of corruption. This was the conclusion. And I remember that case that was stipulating that even the Ministry of Justice of the country from where the investor was approved, actually he said that, yes, I confirm that in the Republic of Moldova the majority of judges were corrupt, are corrupt. So in this case we have a different situation, you know, because it's a public person, it's a Ministry of Justice saying this. So statistically speaking, of course everyone then has the possibility to say, oh yes, but it was approved at the ministerial level, so it means we also faced a corrupt judge. Anyways, in both of the decisions that existed in Moldova, the corruption was the problem. I participated as an expert witness, and for example, in the north, in the village of Roșietic, the mayor was involved, and he registered the contract, and after registering the contract, he refused the registration. I mean, it was like, you know, like in a situation where you marry and then you just declare the people divorced. I mean, it was an obvious case. Of course, by the end of the day, it was gain of a cause. And in that case, there were no evidence for corruption, but nevertheless, it was clear that it was an infringement. Mr. Galas, now I guess we go to the final stage, the conclusions. First of all, I would like to congratulate you and the participants for the organization of such an event. With also the speakers had very interesting speeches. And I want to congratulate also myself that I found time to come here today, because I was not sure previously. I'm a lawyer with a big experience. You see, I have gray hair. And in the same time, I'm an expert in arbitration, but I'm just at the beginning of the road in this path, professional path. And to me, it was very interesting to listen to you today. And all the subjects that were discussed today gives us some hope that the generation that follows will live in a different world and will actually live in a different professional environment. And I think people of my age, they know what I'm talking about, because our fate was to be born in a period of time when these reforms were just at the beginning. And now we are facing already a second modification of the legislation. We had already 3 civil codes. We have now the recent modifications, and hopefully the last one is going to be the final version. Hopefully it doesn't have so many gaps, although I think still we have to discuss about some things that are applicable, but our society might not be ready for them. But this is for another discussion. Once again, I want to congratulate all of you. Mr. Gladey said that let's meet at the next edition, but hopefully we will have the next edition soon, and hopefully we will have essential changes by the next edition. We all want things to happen as fast as possible, but nevertheless, let's make sure we don't give promises. Madam Stamati today gave some promises. Hopefully, we will come to a point where we will actually implement this alternative means of solving cases, and I'm speaking about arbitration. We understand how many efforts need to be taken, but all I can say now is good luck, because I see that people are ready to involve. I want to hear a feedback from the young generation. If anyone wants to say something, maybe Laurentiu, Nicoleta, Mihai, the young generation, who wants to represent the voice of the new generation? Because you are going to be the one taking over after us. Mihai? So, Mihai, do you want to say something before? I'm going to be very short, because I see that we went over the agenda compared to Mr. Blas. I am just at the beginning of my career in the law, and I am actually very lucky to start it now when we are speaking about this in the context of the international arbitration. And it's a pleasure for me to see that in the Republic of Moldova we already discussed those things that are already in the Western books, and I was not expecting this to happen so fast, to take over the experience of the West in the Republic of Moldova. I think it's definitely a big success. We are waiting for the new law. I hope this law will not be just a paper on the shelf. I hope it's going to be an operational tool. Thank you very much, Mihai. Yes, you're right. I think everyone can sign under your message. Okay, then if you are hungry, I suggest we shall go to have some food, because I'm sure that it was a long event, you are tired, it was very intense, it was a pleasure, and it was actually a luxury for me to be here, because we discussed very important matters. And we used to read about those things in books of written by Henry, how was his name? We need to buy that book, by the way. This is the major book in our field. Okay, so this being said, I would like to close the conference, and we invite you, anticipating the next conference, to attend other conferences that we are going to organize in the future. Meantime, let's just sit on the shoulders of the parliamentary people and people from the ministry in order to push them to give us clear rules of the game. And yesterday you probably heard our, you saw my interview with Mr. Burundusuk about applying Anglo-Saxon legislation in our industrial parks, and people will have enough predictability to come to our country and invest, because we definitely have land blessed by God. Have a nice day. Goodbye, everyone. Let's enjoy lunch.